Hi, I'm Mike McCall. I'm an employment attorney in Dallas and a consultant for VFIS. You may recognize me. Over the past 10 years, I've traveled around the country talking to emergency services organizations about a very important subject, discrimination and harassment in the workplace. You may not know it, but this is a serious problem facing emergency services organizations. The number of discrimination and harassment claims continues to rise. This is why I talk to so many organizations to try to get the message out. What you don't know can hurt you. It can cost you and your organization a lot of money, not to mention damaged reputations. I can guess what you may be thinking right now. Working in emergency services isn't like working at the bank or for an insurance company, and the people who sign up as volunteers or get hired know that. They know what they're getting into, so you don't want to hear any boo-hooing later. You're right. Emergency services isn't like other corporate environments, where we think things are a little more buttoned up. We do think of emergency services as having a casual, laid-back environment. After all, you're out there risking your life and limb to help your fellow man. Your work is tough and demanding. You can't be expected to function as you would in a typical corporate setting, minding your P's and Q's. So, what's my point? This workshop is not about trying to shut down or sterilize your culture. That's not my job. What VFIS and I are trying to do is raise your awareness of what is acceptable behavior and what isn't. Even though you may consider everyone you work with to be like family, and you swear they'd never file a discrimination or harassment claim, you need to pay attention. You just can't predict human behavior 100% of the time. What we've done is put together segments from a real workshop I gave to volunteers and employees of several fire and EMS companies on Long Island, New York. In this workshop, I'll tell you what you need to know to stay on the right side of the legal line. I'll also tell you about your responsibilities if you should find yourself in the role of either the offended or the offender. Two things to keep in mind as you watch this presentation. There is no one complete list of unacceptable and acceptable behaviors that you can refer to. And where discrimination or harassment issues are concerned, much of the evidence is subjective. How you feel about the Sports Illustrated swimsuit issue lying around in the lunchroom may be very different from how someone else feels. What we're asking is that you be conscious of your actions and your words and know that they could have a negative impact on somebody else. When you're ready, choose a selection from the main menu. Thanks for watching. In this first segment, I'll show why the issues of discrimination and harassment are relevant to emergency services today. We're going to try to define for you what constitutes unlawful harassment and discrimination. And you might be saying, well, isn't all harassment unlawful? Okay. The answer to that's not really. You know, some of you folks were harassing each other before our session started, but that doesn't cross that legal line. You know, if we could all go to court for being teased, harassed, harangued, joked with, you know, we'd all have our day in court. But as you would probably figure out, there are parameters to get to the courthouse, to go sue in federal court. We're not just talking about a little ribbon back and forth. Okay, so we're going to, again, try to define what constitutes unlawful harassment and discrimination, and also talk about your individual responsibilities. You know, just tell you the rules of the game. That way you know if you are crossing the line, and also if you feel like at any time maybe you're being subjected to unlawful harassment or discrimination, what your responsibilities are to let somebody within the organization know. That way an investigation can be done and it can get resolved in-house. And we'll talk about those responsibilities as well. To not bring the complaint forward and wait and get some attorney after the fact, you're going to be asked, well, what did you do at the time to get this issue resolved? If you really felt like you were being harassed or discriminated against, what did you do at the time to get the issue resolved? There are responsibilities that go along with that from a legal standpoint. Identifying risk. I put up here, don't shoot the messenger. All right? I'm not a lawmaker. I'm not a judge. I'm not saying that, yes, this is the legal line. I'm just going to do my best to show you where that line is. I know that there's a lot of sarcasm, there's a lot of emotion wrapped up with the issues of harassment and discrimination. There are certain people sitting here tonight who probably say, you know, we've gone too far with this. We've gotten too politically correct today. We can't be afraid to talk to each other in our jobs. There are other people who are saying, you know, it's about time we've talked about harassment and discrimination. We're a little overdue here. So I'm not saying that I agree that we've gone too far or that we haven't gone far enough. I'm just going to show you the best I can, again, what the rules of the game are. That way you can abide by them to the best of your ability. And one of the experiences I had was I worked for a federal court judge in my hometown of Oklahoma City. And in working for him, we saw more personnel-related jury trials than anything else in my short time of working with him. Okay? Cases like harassment and discrimination and wrongful discharge. And what was interesting is that all the legalese aside, what this judge cared about is, hey, I just want to make sure that everybody here had a safe and productive place to work. That's all he really cared about at the end of the day. And at the same time, one thing I pulled out of this experience was accountability was very big for this judge. Okay? Accountability on the part of the emergency services organization to do things like training, to make sure that if something happens, they're prepared to investigate it and get it resolved. On the other hand, the judge looked at the person who is the alleged victim of harassment and said, you know what, you have to be accountable too. If this happened to you, again, what did you do at the time to get it resolved? You know, why are we in court 3 years later haggling out this case about was this harassment, was it not? Did you report it in-house? Did you give the organization an opportunity to investigate it in-house? Or did you maybe allow them to bring in a neutral third-party investigator to resolve the issue at the time? Because that's the ultimate goal for the judge was, hey, if it happened, if you were harassed, if you were discriminated against, let's stop it and stop it now. You know, we shouldn't be necessarily dragging this thing out 2 years after the fact. So I think this accountability on everybody's part is kind of a theme that you'll hear tonight. That everybody's accountable for their own actions and behaviors, of course. But again, if it's happening to you, you have to be accountable to get something done about it. Whether you're a paid emergency services worker or a volunteer, you need to understand that there are acceptable and unacceptable behaviors in the workplace. In this segment, I'll define harassment and discrimination and give you some examples. Then we'll get into how you can help prevent these types of offenses from occurring at your facility. Only you can prevent harassment and discrimination on your own turf. First question. We'll start with a softball. Emergency services organizations are held to a high standard for preventing and promptly responding to workplace harassment and discrimination. What do you think, true or false? True. Okay. Let me ask you this. Are you held to any different legal standard than any other business down the street, around the corner? No. Okay. Do you think, you're right, by the way, you're right, you're held to the same legal standard of, you know, is this harassment, is it discrimination, did the organization cross the line, did the individual members cross the line? But let me ask you this, do you think that a judge or a jury that's looking at the same set of facts, okay, let's say it's the exact same scenario that happens within these walls, within the emergency services organization, same set of facts down the street at XYZ Inc. Do you think that what happens here is going to be more harshly scrutinized than what happens down the street? From our experience, what we found is that, yeah, you're held to the same legal standard, but if you think that an EEOC investigator or a judge or a jury is going to look at the behaviors of those in the fire service or EMS differently than what happens down at XYZ Inc., you're right on, because what happens here is going to be more harshly scrutinized. Same set of facts. The harassment allegation. What do you think is going to make the local newspaper? What happens within these walls or what happens at XYZ Inc.? Yeah, you know, the statistics show us and the surveys show us that people in emergency services, firefighters, EMS, and teachers are held to the highest regard more than any other professions in our society. And the reason we point this out is that we realize that there's a lot of sentiment out there that, hey, look, if you can't deal with this kind of talk, and if you can't deal with this language or these comments, you shouldn't be in the fire service. Or, you know, that's just the way we talk in EMS. And that's, you know, again, you're going to be given some discretion. You're not going to be looked at as the stuffy bank, but also balance that out with the realization that in a lot of respects more is expected of you. Okay, so that's not a scare tactic. It's just part of the realities of what we see in emergency services. Okay, and to highlight this, I want to go through just a couple quick scenarios. We had a 10-question quiz that was titled "Sexual Harassment, You Be the Judge." Okay, and we gave these little brief scenarios to a group of 100 fire chiefs at this state conference. Okay, and we asked them, in your opinion, this little scenario, do you think that crosses a line of unlawful behavior in your particular firehouse? Okay, and we'll go through 4 of them tonight, and I want to see what you think. First one, right? Jerry Springer. All right, the particular episode in question was an episode dealing with transvestites, which is just a normal episode of Jerry Springer, as you know. And the transvestites were on there, and every other word was being bleeped, and they happened to start talking about oral sex. And so the question is, that type of programming, the Jerry Springer Show, if someone is offended by that in this particular organization, is that crossing the legal line? Could that constitute unlawful harassment? The firefighters and fire chiefs on that scenario, most of them agreed with you. Okay, not that big a deal. Can't be hypersensitive. Another scenario we had, the Starr Report, right? When the Starr Report came out, a lot of scintillating descriptions of what Monica did with President Clinton, and as you know, Hillary was not happy about it, and Bubba, you know, he was all thumbs up about it. He had a good time with it. So you're reading the Starr Report within these walls, and you're getting into some of the descriptive evidence about oral sex again. Here we are back to that subject. Again, in the conference, most everyone agreed with you. Not that big a deal. Sports Illustrated, swimsuit issue. It's laying around, everybody's talking about it, posting it up, looking at it, Xeroxing it. That big a deal? Crossing the line? Probably not that big a deal is what one or two people said, you know, it might cross the line. Let's flip it around. Cosmopolitan. You know, here's a primarily female-read magazine. This was an article here, How to Have Bathtub Booty. How to have bathtub booty. The article was basically a top 10 list of top 10 ways to satisfy your significant other in the tub. Okay, so I guess it's different in the tub than elsewhere. Where we are on this is that it was interesting. We had about 100 fire chiefs, and we went through 10 questions. About half of the fire chiefs said, you know what, I wouldn't allow that Jerry Springer smut in my firehouse. Okay, I wouldn't let that oral sex talk be thrown around. I wouldn't let these top 10 lists laying around of how to sexually please your significant other. The other 50% said, not a big deal. You know, kind of agree with everybody in the room here. You can buy the magazine off the rack at the supermarket, right? A 10-year-old kid can buy a Cosmo, SI. What's interesting is we took these same questions, sexual harassment, you be the judge, to those who are not in emergency services. And we had a group of 100 managers and supervisors and took them through the same 10 questions, and what do you think their responses were to these scenarios? All 10, all of it crosses the line. One of the comments that struck me, that the supervisor, she says, you know, if we're sitting around in the break room or in the lunch room and our CEO walks in and we've got oral sex and Jerry Springer on, it's turned off. If I come to work and I'm passing around and Xeroxing the Cosmo article on how to have good bathtub sex, you know, I could be reprimanded for that. The reason I point that out again is that if a fire district, if an EMS organization gets sued, gets hauled into court and accusations there, those are the people deciding your fate. Okay? The standard you're held to isn't what's normal in the firehouse or what's normal in the EMS arena. It's what are they used to? What are their expectations at their jobs? And what is good for their workplace should be good for your workplace as well. Again, I'm not saying right or wrong, agree, disagree. That's just what we see, is that, you know, while you are given some discretion, again, you're not the stuffy bank environment. At the same time, there is a line that can be crossed. So we'll explore a little bit more into that. One of the things the Supreme Court says is that, hey, every organization has to meet its responsibilities. And it says, you know what? The employer, the emergency services organization, must exercise reasonable care to prevent harassment and promptly respond to it. And if you have this in place, here's where the accountability shifts back on the member. We see a lot of harassment and discrimination situations where a member of the emergency services organization doesn't complain about the alleged harassment or discrimination during their membership or during their work experience. They quit or they're let go, and that's the first time we hear about the alleged harassment. Okay, so let me ask you, can an organization be held liable for something that you never had the opportunity to investigate? Think so? Why yes? The answer is yes. Doesn't seem very fair. How can you hold us responsible for something you never even complained about? Where's the accountability, right? Fear. This is part of the argument that we see. Members say, you know what? I feared reporting because the person I was to report to was part of the problem or knew about the problem. Okay? I was intimidated. I didn't want to be seen as a troublemaker in this environment. Okay? I would just be isolated and run out if I did complain. I had no other choice but to quit and get an attorney. So an organization can be held liable for something it was never notified about. But at the same time, we also see that employees and volunteers do have certain legal responsibilities. And let's look at question 2. Employees and volunteers have a legal responsibility to utilize safe and reasonable internal reporting procedures should they observe or be subjected to workplace wrongdoing such as harassment and discrimination. What do you think? True or false? The reason it's true is that, you know, it's true that you can quit, and that could be the first time you complain about it. But you're going to be asked why you failed to complain at the time during your membership with the organization. Okay? Here's where the judge I worked for is going to hold everybody in this room, every employee, every volunteer out there in an emergency services organization. Any judge is going to say, hey, you got to be accountable too. If it happens to you, here's what the U.S. Supreme Court says. It says you must take advantage of any reasonable preventative or corrective opportunities provided by the employer. Okay? So while it's true that you can say, well, I was intimidated, I had fears, I had no other choice, you will be asked why you failed to complain. Because if there were safe avenues of complaint, you're going to be asked why you didn't use them. If you didn't trust any internal investigation whatsoever, you're going to be asked, well, why didn't you give the organization the opportunity to have a third-party investigator come in? The courts are already flooded. They want organizations like this to deal with your own problems in-house. Okay, they can only try so many cases. They want to know what the organization did to prevent it and what the employee or volunteer did to get it resolved. That's hopefully going to make everybody feel like there is some accountability in this arena. Personal accountability. So, where we fall on this accountability issue is that the courts are telling us that organizations must encourage reporting. That's part of why you're here tonight. All right? You've got to encourage it. You've got to advertise policies and procedures. You've got to have systems in place to be able to investigate complaints when they come in. And that's why I mentioned that third-party investigation. If you have somebody that says, I don't trust any internal investigation, that's why you can bring in a third-party investigator. So that's the accountability on the part of your organization and every other organization out there. Ryan's coworkers frequently and relentlessly taunt and mock him about growing up in Oklahoma. Ryan, a probationary member of the Emergency Services Organization, and now only referred to as the Okie from Muskogee, feels so isolated he feels forced to quit. Ryan is being subjected to unlawful workplace discrimination. Just to kind of capture the discussion. One side says, hey, it's not sexual in nature, it's not racial in nature, it's certainly ridiculing the guy, but maybe not unlawful. The other side says, hey, frequently, relentlessly taunting him, mocking him, he's forced to quit, it's affecting him psychologically, he's got to leave. The answer here is actually false. And here's the reason. It doesn't mean that the organization shouldn't take action on it. Okay, if the guy's being run out of there because he's an Okie from Muskogee, you probably want to take some action on it. But could Ryan go to court and sue based on a civil rights violation because he's being teased because he's an Okie from Muskogee? The answer to that's no. Okay, so it's just a differentiation of legally protected classes. For something to be unlawful according to Title VII of the Civil Rights Act, federal laws, it has to be based on legally protected classes. But again, we ask leaders all the time in emergency services organizations, would you want this going on in your organization? They say no. We don't want anybody run out, whether he's an Okie from Muskogee or whatever the case may be. Okay? So part of what we look at with discrimination is that situations like this could and should be worked out with common sense. Okay, shouldn't ever really spiral out of control in the first place. But when we talk about an unlawful hostile work environment, we are talking about a hostile work environment based on sex, sexual innuendos, racial overtones, age, okay? All the protected classes, you can have a hostile work environment based on those issues. So again, race and color, religion, gender, national origin. If you're over 40, you're a member of a protected class. Age discrimination. Disability, sexual orientation, military status, marital status. Okay. Sexual orientation is not recognized as a federally protected class. Okay, but individual cities, townships, states can pass legislation saying we don't allow our employers to discriminate based on sexual orientation. When we talk about discrimination law, we're not talking about preferential treatment. We're simply talking about equal treatment. We're not talking about affirmative action or quotas. We're talking about the law of comparison. You're basically looking at how those who are members of a protected class are treated versus those who are not members of a protected class. Okay, it's a law of comparison. When typically do we see discrimination? Well, if someone's refused membership, refusal to hire, someone's demoted, someone's not promoted, someone's terminated, okay? Someone's denied benefits, someone's denied training. These are all examples of when discrimination could take place. The last bullet point here, however, is where we see some of the gray area and also the more frequent, I would say, examples of discrimination. Maybe it's not as tangible. Maybe it is someone who is treated differently, receiving different conditions or opportunities as others. They're isolated in the work environment. Okay? I'll give you an example. I was doing training with a fire district not too long ago, and there happened to be one African American gentleman in the class. And during breaks and before the session, no one talked to the guy. And I'm not saying that, this was a discriminatory fire department, but it was interesting that he was the only guy that no one talked to the entire 3-hour session we had. And that type of behavior where someone says, you know what, when I walk in a room, all the conversation shuts down. If I'm in a room and I don't like the conversation, I'm told to hightail it elsewhere. Okay? If I don't like what's on TV, they tell me to get the hell out. That type of isolation to an extreme extent can be an example of discrimination as well. So that person could receive training opportunities, same job benefits, whatever it may be, but he's isolated and treated differently. That can be an example also of workplace discrimination. When we think of especially sexual harassment, we have a lot of mixed messages. One of the reasons we're here is that we are kind of working with the double standard. All right? You watch Will and Grace on NBC, you watch NYPD Blue, whatever it is. If I come in here and use that same language to talk about that same subject matter, am I all of a sudden in a sterile work environment and that crosses a line? Okay? We talked about Cosmo. We talked about movies. All right? We also have the issue of relativism. What this guy thinks is crossing the line might be different than what I think is crossing the line. So who decides? If this guy's a little hypersensitive and he's offended by something, does that make it harassment? So we'll get into some of that. While there is no all-inclusive list of bad behaviors for you to keep in mind, there are boundaries you should be aware of. In this segment, I'll describe what a hostile work environment looks like and what you can do to help keep the peace. What are examples of harassment?
Slaps on the behind.
Okay. Touching, absolutely. What else? Name calling. Okay. Comments, innuendos, advances, threats. Okay. You won't get promoted unless you go out with me or have sex with me. The last bullet is where we see most of the discrimination and harassment claims. Okay, it's the jokes, it's the comments, it's the innuendos, it's the leering, it's the looks. Again, kind of the gray area. It's pretty obvious if someone threatens your membership here and you get fired because you denied their advances. That's pretty clear. Where we see the gray area and where we're going to explore mainly today is comments, innuendos. When are we crossing that line there? Obviously, the behavior has to be unwelcome. Okay? So this gentleman here probably isn't going to have a successful sexual harassment claim, I'm guessing. Okay? Probably not. You have to be accountable again. You can't be the worst offender and then the next day say, oh gosh, I'm offended by those sexual comments and innuendos. Because you've let it be known through your own words and your own actions that, hey, this type of talk's welcome to me. Okay? You have other people who, for whatever reason, might be religious or moral, or they just don't believe in that kind of talk or behavior. They might outwardly reject it. So obviously, if you cross that line after someone rejects those comments or those behaviors, then that might be crossing the legal line of unlawful harassment. What about somebody that initially accepts the behavior or comments and they later reject it? Okay, first they're the ones going right along with the comments and the jokes, but they later say, hey, I'm now offended by it. Do you think that's ever done? Sure. What I'll say about that, however, is if I'm the worst offender and all of a sudden I have a change of heart, okay, and this is now offensive to me, that puts more of an obligation on me to let you know that what used to be acceptable is no longer acceptable. Okay? You can't read my mind. So I do have a responsibility to let you know, hey, I don't want to engage in that kind of talk or that type of activity anymore because I have had a change of heart. Now the last issue here is where we see some gray area again. Someone that says, you know what, my acceptance of the jokes, the comments, the innuendos, it appeared to everybody that it was accepted. I laughed at the jokes. I went along with it. Maybe I wasn't an active participant in saying the things myself, but I never complained about it. But the whole time I was dying inside when I had to listen to this guy throw around racial slurs or sexual comments. And I took it. I had a smile on my face the whole time, but it was unwelcome the whole time. We see a lot of cases involving that. The moral of this story is, just because somebody doesn't tell you, hey, that's offensive, don't assume that it is welcome. Okay? Perception isn't always reality. We're all familiar with Anita Hill, right? Anita Hill and Clarence Thomas. Anita Hill worked for Clarence Thomas. She was asked, hey, why didn't you complain at the time? You never said anything to him. You never said anything to anybody else at the time. She said, you know what? My acceptance at the time was coerced. I didn't have another choice. This was my boss. Does anyone know what Clarence Thomas's position was, what his job was, when he allegedly harassed Anita Hill? He was not a Supreme Court judge yet. No, he wasn't Solicitor General. He was chairman of the Equal Employment Opportunity Commission. All right. So she says, well, who are they going to believe? The chairman of the EEOC or me? Who can create a hostile work environment, whether it's sexual in nature, racial in nature? Anybody, right? Volunteers, paid, temporary workers, visitors, vendors, commissioners. All right? Anybody can create a hostile environment. Can women sexually harass men? Some men would disagree. Some men would say, harass me all you want. Let me ask you this. Do you think we see many cases where a guy says, you know what, her sexual jokes and comments and innuendos were really offensive to me? Yeah. Not in New York, right? Not in Texas, where I live. California, maybe. Where we see some cases where a man says, hey, I was sexually harassed by this female, typically is a supervisor-subordinate situation. Okay? A supervisor that says, hey, I don't care if you're married, but you and I are going to have a thing going here, or you don't get that promotion. Okay? Typically, it has to be a pretty serious threat of someone's job, which happens. I've worked on cases where men were threatened with their job. They were married. They didn't want their spouse to find out that he was being hit on by the supervisor because maybe his wife was going to think that he was leading her on or there was something going on. We've seen cases where, yes, men harass other men. You have a guy that makes sexual advances and he's the boss. A lot of you are probably sitting there saying, I'd knock the guy out. Okay? You'd be surprised in my profession, the men that have come to me and said, you know what, I never reported it because, number one, he was my boss. He could affect my career and my livelihood. I had a couple kids. And there was a fear there with this one gentleman that I'm thinking of in particular. He said, you know what, I personally didn't want people to think that I might have led this guy on. I don't know what he could say. He could say that I'm the one that hit on him. So we see some male-to-male harassment. Can women harass other women? Absolutely. Verbal or physical conduct, we talked about touching, we talked about comments, can be of a sexual nature, religious nature, racial nature. Here's where we start to separate what crosses the line. Does the behavior, do the comments unreasonably interfere with your ability to do your job? The courts don't use language like, you know what, if you're bothered a little bit by it, if it's annoying to you, if it's a hindrance in you doing your job, that's not good enough. You know, we're not, again, if we could all go to court for being harangued, for being teased, for hearing a dirty joke every now and then, we'd all go to court. The courts would be flooded that much more. Part of the separation is that, you know what, does the harassment, do the comments, do the behaviors unreasonably interfere with your ability to do your job? That's a pretty tough standard, okay? We don't live in the Beaver Cleaver Society anymore, so we can't run our work environments like that, okay? But still, we're going to get into that realm of crossing the line. It's got to create this intimidating, offensive, or hostile work environment. Pretty strong language again. All right? So those of you who are saying, oh gosh, you know, sterilizing the work environment, I can't say anything. You know, you're given some discretion here. No one's telling you can't say darn or damn or whatever it may be. There's a line. Let's look at question 4. One sexual comment may be considered unlawful harassment. True or false? Maybe one comment isn't that big a deal. You know, one joke, one little remark. However, if it's the one sexual comment that is, hey, you know, you have sex with me or you don't get promoted, that's different. One little sexual comment about what was on Will and Grace last night, probably not. Most likely not. Okay? What if it's one comment but it's racial in nature? Is that treated differently than maybe the sexual comment?
Yeah. Oh, yeah.
Most likely, okay. One racial slur, most of the time, that's enough. One sexual comment, joke, innuendo, most likely not, okay. Depends on the circumstances, depends on how the term is used. Dealing with an emergency services group, they're going out on a call, actually coming back from a call. They're driving down the road. It's a nice, pretty summer day. There's a mother reaching into her SUV. She's got a couple kids running around, and she's got some little short shorts on. And one of the guys says, "Man, look at that MILF." For those of you that don't know what MILF is, it's a mom I'd like to fornicate with, right? So the context there, one comment, okay, one comment. Says it out in the open. Was it mean-spirited? Was it directed right at that person? Could that person hear it? You know, maybe a little different than you take that same phrase, that same expression, and let's say you're alone with one of your fellow members of the organization. No one else is around. You look that person right in the eye and say, you know what? You're a MILF. Give them that look, right? That's different. That could be one comment based on the context, based on the fact that no one else is around, based on the fact that it wasn't just thrown out there for everybody to hear. You could take the same language. How about number 5? Frequent sexual comments constitute unlawful harassment. True or false? Okay, that's a big factor that you look at in determining whether or not it crosses that line. Especially if someone says, "Hey, that's offensive to me," and you continually say it. Okay. However, you could maybe have a couple comments that, again, they're joking in spirit. They're not that offensive. They might be sexual in nature, but they're not overtly sexual. They're not threatening in any way. They might be jokes. May or may not be harassment. Let's look at these two questions. One sexual comment or one racial comment, or the frequency. 2 slides we're going to have will define to the best of our ability whether or not these behaviors, comments, behaviors, touching, no matter what example you're thinking of, you have to meet a few tests. First thing is, was the conduct severe? Okay. The first standard is severe or pervasive. You don't have to have both to fall into that realm of unlawful harassment. It can be so severe that it only has to happen once, that it crosses that legal line. You may only have to use the N-word one time, and that's enough. One sexual comment where you are threatening somebody's job, It's probably enough. Okay? Didn't have to happen again and again. One time might be enough. But what if it's just one sexual joke, comment, not that big a deal, perhaps? It probably won't meet the severe standard where that one comment alters that workplace experience from that point forward. But what if it's pervasive? What if it's so frequent that it becomes a defining condition of the work environment? Okay, every time I work with this guy, it's a different racial comment. One comment in and of itself, maybe not that big a deal. But it becomes a defining condition of working with him. I know that for the last 6 months, I've worked with this guy, and every time I'm around him, it's a different racial comment, racial joke, different sexual joke, okay, such that it becomes a defining condition, such that if one single act, one single comment, one single joke may not be a violation in and of itself, but it's the cumulative effect. Okay, that's pervasive. Everyone with me on that? Severe or pervasive. Well, the next question is, well, according to whom? You know, one joke might be enough for you, may not be that big a deal to me. It's all relative. Let's look at question 6. Tom is extremely offended by sexually related comments made by coworkers while on the job. Because Tom regards the comments as offensive and unwelcome, the coworker statements would be considered sexual harassment. Tom is vehemently upset about these comments. Totally crosses the line for him. He's offended by it, no doubt about it. He's pounding his fist on the table. Crosses a line. Is it harassment? It might be harassment, but here's the moral of this story. Okay? Just because Tom says he's offended doesn't make it unlawful. What if Tom is hypersensitive? Okay, we don't define what the sexually related comment is here. All right? Who remembers the Seinfeld episode about... I mean, everybody knows the Seinfeld episodes. The Seinfeld episode where Jerry makes out with this girl, forgets her name. Okay? The whole episode was him trying to figure out what her name was. So he says, you know, he's kind of fishing. He's like, you know, I can't ask her what her name is because I've already made out with her. So did kids make fun of you growing up, you know, about your name? She says, well, of course. You know, my name rhymes with a female body part. So the whole episode, as you recall, was Jerry trying to figure out, well, what's the female body part and what's her name? And so you recall that. True story. As you do with the Seinfeld episodes, you're sitting around the water cooler talking about the latest Seinfeld episode that was on last night. And the guy's talking about, yeah, you know, at the end of the episode, they found out what her name was and what the female body part was. And someone says, well, what was it? And they tell them, and the person says, well, what is that female body part? I don't even know what it is. I'm not an anatomy expert. So somebody in this particular work environment goes and gets a dictionary and looks up the word, female body part, and says, this is what it is. Well, we had a Tom in this particular work environment. Tom was offended by it. He didn't like the fact that we're sitting around talking about female body parts, and he goes in and complains that, hey, this is harassment. If it happens again, if this guy isn't disciplined, freaking out about it. Well, this particular employer, because of being hypersensitive themselves, says, gosh, we don't want to take any risks here, so they discipline this guy. They actually fired the guy who's pointing out what the female body part is because they were so scared of a harassment claim. Well, the way that case worked itself out was that the person who was fired sued for wrongful termination because the judge said, you know what, we can't be firing people for talking about what's on Seinfeld. All right? That's on NBC. I don't care how offended Tom is. Just because Tom's offended by the sexual comments doesn't mean it's unlawful. What if Tom's hypersensitive? Just because you say it's harassment doesn't make it harassment. But let's look at the next question. We have a little balancing out to do here. Tammy receives multiple email jokes that are sexual in nature. And again, these could be racial in nature, religious in nature. Receives multiple email jokes from coworkers. She forwards these emails to friends outside and within the emergency services organization. Most reasonable people would believe the content of the email messages is offensive and would probably constitute sexually harassing material. A couple weeks later, Tammy lodges a formal complaint with the organization stating the co-workers that sent her the emails are guilty of committing harassment. Is Tammy's complaint valid or invalid? Here's where the balance and accountability comes in. Okay? If everyone in this room said, hey, the content of the emails is inappropriate, you meet part of the standard, but you know what? If Tammy's the worst offender, she can't then go off and successfully sue for harassment because she can't prove that it was offensive to her. Let's go through this. We talked about the severe and pervasive, right? Severe and pervasive. The next question is, you've got to satisfy two more tests. First, the subjective test. The person complaining must be able to show that he or she was personally offended by the behavior. So Tammy, by passing the information on, by you being the worst offender, telling the racial jokes, the sexual jokes, you're not going to be successful. Okay? No matter how offensive it is, you've got to be accountable. Madonna the singer defense. Something that could offend everybody else in this room, Madonna the singer is probably going to have a hard time winning that sexual harassment lawsuit. Okay? Because she has posed nude in books, maybe some foul language, whatever it may be. Okay? You've got to meet both of these tests. You've got to be personally offended by it. The second test you have to meet is called the objective test. The objective test says that, you know what, most reasonable people out there must also agree that the behavior in question crosses that legal line. So this is where we get Tom. You know, Tom meets the subjective test, right? He was offended. There's no doubt about that. But if most reasonable people don't agree that what Tom had to hear crossed that legal line, it's not unlawful harassment. So this is where the balance comes in. You can't let the worst offender be the one complaining the next day. And you can't also let somebody who's a little hypersensitive be the tail wagging the dog. And we've seen cases like this in emergency services organizations. The guy who flips out because Maxim magazine's laying around. You know, particular case, this guy was a ordained minister. That's what he did. Volunteer firefighter. He was offended by it. He pounds his fist saying, I can't have Maxim magazines laying around here. Well, he was offended by it, but most reasonable people said, you know what, we can't agree that having a Maxim magazine laying around every now and then crosses that legal line of unlawful harassment or discrimination. Everybody with me? All right. There is some balance there. Some other language just to show you that we can't have the tail wagging the dog. We're not hypersensitive. We're not the beaver cleaver generation. But there is that line that can be crossed. Other language we see, again, to remind you, does the behavior, do the comments, does it unreasonably interfere with your ability to do your job? Is the language or behavior kind of shocking? Okay? Again, Jerry Seinfeld, talking about Jerry Seinfeld, that's not shocking. That's NBC, right? 7 o'clock. Are the words used as a weapon? You know, the MILF example, all right? There's a power issue there. That's different than the guy just throwing out some little joke, okay? One was used as a weapon, one was not. So you have to look at the context of it. Number 8, question 8. Employees or volunteers must first tell the person responsible for creating the uncomfortable, harassing environment to stop making the comments or otherwise cease the behavior in question. What do you think, true or false? Most situations can resolve themselves. If my joke's offensive to you, just tell me and I'll stop telling them around you. But the question focuses on, are you required to confront the person? Are you required to go to the person and say, hey, it's offensive to me? You're not required. Correct. You're not required to do it. Legally, here's the reason why. Okay? The reason why is we've seen cases where in good faith, you have someone that says, hey, go tell him it's offensive. You know, if the sexual jokes or comments are offensive to you, just go tell him, he'll stop. You need to go talk to him first before I pursue this complaint. We've even seen policy language that says, hey, if you believe you're being harassed or discriminated against, you need to tell the person to stop. Sounds like a good faith thing to do. That could be all the reason the person needs to say, you know what, I feared confronting the harasser. I wasn't comfortable confronting the person who was creating the discriminatory environment for me. Therefore, I had no other choice but to quit and get an attorney. Okay? You can confront the person if you want. You can approach them if you want, but you're not legally required to. But as we talked about earlier, you do have a legal responsibility to let somebody know within the organization. That way an investigation can be done, either internal investigation or a third-party investigation. Question 9. True or false? Employees or volunteers can only be held responsible for their discriminatory statements or actions while they're on duty. Even if something happens off duty, and let's say you're at the bar tonight and you're throwing around racial slurs, and you go work with those guys later tomorrow or the next day, that's still in the air. Okay, you're not just off duty and those words don't come back into work with you. The point here is we see cases where somebody says inappropriate racial comments off duty to a fellow worker. They go work with them the next day. What jury is going to believe that, you know what, he only threw those racial slurs around at the bar. He never said those things here. Question 10. If an employee or volunteer requests that his or her supervisor keep a report or allegation confidential, many courts recognize the legal obligation placed on the supervisor to keep the information confidential. Otherwise, the constitutionally protected personal privacy rights are compromised by the supervisor-subordinate breach of confidentiality. You go to a supervisor and say, hey, I'm going to tell you this. I don't want you to investigate it. I don't want you to take it any further. I don't want to make a big deal about it. I'm just confiding in you. If it has to do with harassment or discrimination, what responsibility does that supervisor have under those circumstances? You cannot keep it confidential. That's not the supervisor's decision of, hey, I can't let you down here. I know we're friends. Legally, once that supervisor's put on notice, it's as if a commissioner's put on notice. It's as if the fire chief's put on notice. Okay. The principle here is what we call the agency law principle. Basically, any supervisor within this organization or any other organization, because of having that supervisory authority, once that supervisor's on notice, that supervisor that's acting on behalf of the organization, once on notice, that information, that knowledge is imputed all the way up to the top in the chain of command. Okay? So that supervisor is under an obligation to take action. Okay? Has to take it forward, even if the person says, no, I don't want you to take it forward. And we see those cases all the time. I'll give you an example of a recent one. Complaint comes in. Firefighter says, hey, I just want to talk to you about this. I'm kind of venting here, but I don't want anything done about it. Talks about a potential harassment or discrimination scenario. Supervisor says, okay, I'll keep it in confidence. 2 months later, the firefighter quits, sues. What do you think that complainant said about what information was given to the supervisor?
Told the supervisor that I was having a problem.
Told the supervisor didn't do anything about it. The supervisor says, you told me to keep it confidential. I never told you that. We see that time after time after time, and that's just the legal responsibility that's on a supervisor, is to act on it. And that helps separate, quite frankly, the venting and the people that just want to come in and complain. If you're going to complain, you have to expect that something's going to be done about it. And this is the confidentiality thing. Okay? You're going to keep it as confidential as possible. You're not going to spread it all over the organization, but you have to keep it as confidential as possible. but you cannot guarantee absolute confidentiality. You have to have enough information to the people who have a need to know. That way it can be investigated. Question 11. True or false? The majority of U.S. federal courts have decided that it is unfair and unlawful for an employee to be terminated if the employee didn't intend to harass or otherwise offend another employee. Less severe progressive disciplinary measures are more appropriate. I didn't intend to offend you. It was a joke. It was just an off-the-cuff comment. Is that any type of defense? Legally, no. You know, if you intend to offend somebody, if you're using words as weapons, it's going to be looked upon as being that much more unlawful. Okay? But the fact that, boy, I didn't know that that was going to offend you so much, it's the impact on the individual which is more determinative than the intent of the person making the comments. Okay? Again, just because I'm impacted and I say it's unlawful doesn't mean it's unlawful. Right? Has to be offensive to me and it has to be offensive to most reasonable people. How about question 12? Fred is offended by two of his co-workers' jokes and comments about African Americans. Fred's a white male. Therefore, he has no legal standing for a discrimination complaint. He couldn't go to court and sue for racial discrimination because he's white. True or false? You know, technically, if Fred is a white male, and he could be just as offended as any African American, but because he's a white male, he wouldn't be able to go to court and sue for that unless he's married to an African American, he adopted an African American child, there's some sort of, you know, and again, it's not to say that he couldn't complain in-house. It's not to say that it's not inappropriate, but we're talking about a little bit of legal standing here, and the moral of this story is exactly that. You never know how your words can impact somebody. You don't know the family history. You don't know all these sorts of things. I was talking to a firefighter after a training session recently. He came up to me and he said, you know, Mike, that example you gave about the African American and the white male, he says, I was at the chiropractor's office recently, and I'm talking to this chiropractor. This guy happens to be white. My chiropractor's white. We're talking about our kids. This guy's working on my back, you know, putting me in all these positions, and they're talking about their kids, and he says, yeah, my kid plays basketball. Your kid plays basketball? Yeah, he does. What school does he go to? Well, he goes to North High School, and, oh, well, my kid goes to South High School. And the firefighter says, you know, this guy's working on me, and I say, you know, your son's got one thing going against him over there at North High School. It's a big high school. You know, he's white. You know, white kids don't get to play over at North. And the guy says, well, actually, my son is black. He's adopted. And, you know, this guy said, I've never felt like a bigger buffoon in my life. You know, insert foot in the mouth, the whole 9 yards. It's just an example of the diversity issues that we ought to be aware of. How about question 13? Two members of your organization are of Asian descent, and they regularly tease each other and make derogatory remarks about their ethnicity. Neither party is offended by the verbal sparring. However, it's overheard by another member of the organization. This exchange could still be considered unlawful discrimination or harassment. True or false? True. You don't have to be the target of the comments. You could be a bystander. If the two people are, it's welcome between them, but those words are out in the air, and if someone of Asian descent is offended by it, they have a right to complain. Question 14. False allegations of harassment or discrimination can result in discipline, up to and including termination for the person making the complaint. That is true. There is some pretty strict language, however, that goes with false allegations. If Tom was offended by something and thought it was harassment, in our earlier example, he's offended by the sexual comments, he might in good faith believe that it's harassment. But it's not, his accusation turns out to be false. It wasn't even close to harassment. That's different than what we're talking about. What we're talking about in terms of false allegations Did the person intentionally make false allegations? Were these malicious allegations? Were they knowingly false? Were you making a good faith complaint? And let me tell you, we see cases all the time where somebody says, you know what, I'm going to get old so-and-so back. And I'm going to make this complaint, and I'm going to get his ass. Okay? As the gossip typically goes, people can't keep their mouth shut. And the person who's making the intentionally false accusation typically is going to tell one person, and that person's going to tell another person. And we see situations where it comes back through the investigation that, hey, this person was out for this guy. It was intentionally false. And can that person be disciplined up to and including termination? Absolutely yes. We're finishing up here. Hopefully, it would be nice if we all knew what the laundry list of crossing the line, inappropriate words are, but we don't. We can only take each case on a case-by-case basis, look at the circumstances, and try to decide, are we drawing within the lines, or are we drawing outside the lines? Are we crossing over that legal threshold? And I hope that the aspects of severe, pervasive, and objective and subjective. If it happened one time, clearly crosses the line. Or what if it happened frequently? The cumulative effect. Were you personally offended by it? And would most reasonable people be offended by it? That's the four-part test. Any hostile work environment scenario, you can take it through that analysis, and it will best define for you whether or not you're playing with the rules. Okay? Playing within the rules. Any questions as a group? I appreciate your time. I know that 2-hour training session going to 9:30 is tough on anybody. I appreciate your attention, appreciate your participation, and I'll stick around afterwards for individual questions if you'd like to ask some. So I appreciate it. Thanks.